Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book from Oxford University, OUP. They produced this book, International Investment Arbitration. It's now in a second edition. It's this book here. It's Substantive Principles. As I said, it's been updated, and the authors are Campbell, McLachlan, Queen's Counsel, Laurence and Matthew Weiniger, Queen's Counsel. It's come to us from OUP. Elizabeth and I talked about this book. She wrote the main review, and we've given for our book review title the following title: Of Interest to International Lawyers and Arbitrators. The latest arbitration title from OUP, now in a second edition. And that's really the statement of the obvious, if you like, because this is an important book in a substantial area of law. Now, it's part of what is called the Oxford International Arbitration Series, which is mentioned there. You can see the basic front cover there. Then the spine there. There's nothing on the back. It's a hardback brown cover, and it's runs to 630 pages. The way in which it's structured, the index, is by paragraph numbering, very much the house style of OUP, and it's a detailed index too. And then there's a select bibliography just before the index, so you've got a huge amount of detail, as to be expected. It's a very high quality publication, as are all the OUP publications. This is the list of the Oxford International Arbitration Series, which you can see listed there. Then that's the actual book itself. And after that, we move on to detail about Oxford there. Then there's a useful preface to the second edition, which is covered there. And then there's a preface which is included for the first edition, which is just there. And then again, the main preface for the second edition is covered. There's a lot of prefacing going on. The law is as stated 1st of June 2016, and then you've got a summary, excuse me, a summary of the contents there, split into three parts: an overview, ambit of protection and substantive rights, 9 chapters in total plus appendices. Then you've got the detail of the actual contents, a lot of detail as well. So you should be able to find things pretty quickly from what you've got there. There are 13 appendices at the back, so there's a lot of additional detail which is available. Then you've got the table of cases, which runs for some way, and then table of treaties, of course, which are very important by country. And you've got a very useful list of abbreviations, which I think is very important in this area. Then you've got frequently cited texts, which are also listed, which again I think is quite helpful, because this has got an international flavour throughout. And you see the structure. Part 1 is the overview. Then you've got your chapter. Then you've got the mini index there. Then you've got the main book, and then you've got the paragraph numbering there. And you've got the footnoting, so you've got quite a lot of stuff all the way through. And you can see how it runs. This is dispute resolution we're looking at there. It's the overview. Then you get into the ambit of protection itself. It's looking at nationality. Then after that, substantive rights. That's dealing with expropriation. Then at the back you've got the various appendices, which you can see there. It's a heavy book, a good book. And it's one I think that's well worth looking at, knowing about, especially if your practice is within arbitration itself. Now, what do we say about the book? Well, we say this, that 10 years ago the first edition of this book arrived, and it was actually the first volume to be published as part of the then new Oxford Arbitration Series from OUP, under the editorship of Loukas Mistrelis. Now, 10 years later, what has come to be regarded, we think, as a very authoritative, if not definitive, legal text on international investment arbitration has been published in a new edition, researched and written collaboratively by the 3 expert authors that I've mentioned. That's McLachlan, Shaw and Weiniger. Each, of course, of them are authorities in specific aspects of what is a rapidly developing field. And I think it's going to become more important. I have to mention Brexit here to a certain extent, because arbitration, London certainly is a main centre with places like Singapore and, funny enough, Korea. But the important point that I would make here is that notwithstanding the problems of withdrawal from the EU, the London arbitration facility, if you like, that's offered, I hope will remain, notwithstanding any of the other problems that we're facing. And that means, of course, that it is a rapidly developing field at a time when everything is becoming much more global. And I don't see that changing. I mean, if it does, it would be, I think, probably a pretty substantial backward step for humanity, but that's another issue. And it's interesting, also not to mention reassuring, that the three authors hail respectively from Herbert Smith, Linklaters, and Victoria University at Wellington Law School. And they provide, I think, certainly I understand law school provides a very helpful research grant. And that's, of course, what you need here, because this is a scholarly work. I think it'll be of interest to practitioners too, but it's fundamentally a very scholarly work for the academic community. And now the authors are keen to point out that in 2008, the first edition of this text was described by the judges at the J.F. Northey Memorial Book Award as, quote, a lucidly written text that will undoubtedly attain international standing, which certainly is, you might say, and it certainly has. And the changes made to this new edition offer ample evidence of the speed at which investment arbitration has developed over the last decade, during which time, say the authors, a whole new field of scholarship has emerged. What the book aims to do is to provide a dispassionate analysis of the key substantive principles applicable in investment arbitration, with a view to assisting disputing parties and their advisors, as well as academics and just possibly the general public. As I said before, though we're talking here about investment arbitration, the basic principles still apply that London certainly would like to be perceived to be a place where people will come to have their disputes resolved. And I realise that the common law is seen by many countries to be, because it is the greatest of all legal systems in my opinion, it therefore means that they will come here to have resolution of disputes. But, of course, this is no mere update, this book, say the authors, or rather the series editor says that. And in his preface to the latest edition, he commends the authors for taking account of the substantial developments in this field, both positive and negative, including the emergence of new international treaties. And in fact, that's going to be the future. When you think about Brexit and all the problems, we are going to have to carve out all sorts of new agreements. They will be by way of treaty, and they will have to be binding and international, of course, in origin. And, of course, the author here, the series editor rather, refers quite frankly to the ongoing debate as to the legitimacy of investment arbitration, referring to the so-called backlash. But whatever opinions or attitudes are entertained by the book's potential readership, the authors tackle this sometimes controversial subject with laudable objectivity in our view. And there's certainly no doubt that the book excels as a research resource, and scholarly it is. Note the extensive footnoting and check out the 8-page bibliography listing reports, books, articles and so forth. Luckily for practitioners and scholars, the book is logically structured and easily navigable, and I think you'll find that the little index at the front and so forth of each of the chapters is very helpful indeed. There's a minutely detailed table of contents, a 27-page index, and no less than 13 appendices, consisting mainly of international treaties and agreements ranging from, for example, the North America Free Trade Agreement, Chapter 11 of the ICSID Convention, finally, World Bank guidelines on the treatment of foreign debt investment, direct investment. So you can see there are a wide range of global influences here. Let me conclude by saying, illuminating a complex subject with thoroughness and clarity, this new edition of International Investment Arbitration will be welcomed by international lawyers and arbitrators specialising in this field. And I think it's come at a timely moment with the changes that we're expecting in the next few years. And the publication date is cited at 2017, although in fact the law is stated, I believe, is as at the 1st of June 2016. Now this is the book again. Let's have a quick look at it. Just in the middle, there we go. You've got the paragraph numbering, you've got lots and lots of footnotes, a lot of detail, and you've got, it's quite a thoughtful book, and you do have to have some pretty substantial knowledge to follow the intricacies of it. Here we go. We're looking here at substantive rights compensation. That's in chapter 9, for instance. And then just to remind you at the back, you've got a very useful, very detailed index. Very much the house style, in fact, of OUP. I'd like to thank everybody involved in this book very much indeed for producing it. You do make our lives a great deal easier. One of the reasons I review these books, and I always give them a high rating, is because they're the top of the field. I don't review books that, frankly, are not that good, because it just hurts the authors and it doesn't help the publishers. But the purpose of this review is that you know about this book and its worth and availability, depending on what your activities are. But a big thank you to everybody concerned. Bye-bye.